Morning, Mr. Young.
Good morning, my lord. Good morning, my ladies. My colleagues asked me how long I'm going to be. Was I going to be an hour? And I said, in all frankness, I've got no idea. But I think your lordship was good enough to indicate that you thought 2 days would not be required for all of the human rights issues. So it may be that there's a measure of elasticity built in. But just if I may, and please tell me if it's inappropriate, if there are particular areas that you would like me to concentrate upon and particular areas where you would like me to concentrate less, please.
There is one point that's come up overnight in discussions amongst the court that it would be good if you could try and address. It seems to us that there is an argument for suggesting that on question 3, a proper analysis of both the Advocate General and the court, and you know the passages we're talking about, would seem to suggest that at paragraphs 39 and 40 of the court's judgment, it recites the third question. And the third question very clearly states, is there res judicata of the award and the judgment that can be taken into account under Article 34.1 if answers to 1 and 2 are a particular way. And the Advocate General has not, because the Advocate General treated it lightly and said the answer was different to questions 1 and 2, he said, I'm treating it lightly, and he does not answer that question. He does talk about, I mean, I know your point may be, well, it's a complete regime, lex specialis, blah, blah, but he doesn't specifically say at all that he's talking about the award as distinct from the judgment in terms of the award. Well, you can show me where he does.
No, my lord, yes.
I'm assuming for this purpose he doesn't, so as to get to my question. And my question is, why then should we assume that the court, which also doesn't make that distinction, having recited the questions at 39 and 40, why should we assume that the court has decided that Article 34.1 cannot apply to what I call loosely the sanctity of arbitration and the award itself?
Yes, I think the way that I was going to address my submissions, and as I've reconstituted them overnight, I think I'd seen at least the latter part of your lordship's question. I'm not sure.
It was all one question, I think.
Yes, well, yes, I would hate to be accused of saying part 1 of the question and part 2.
It's all issue estoppel. It's the point that the judge made about issue estoppel arising from the award.
Yes, indeed. Yeah. The point at which I would just like to reflect a little more is whether the Advocate General did in fact not say that, as your lordship has mooted, has not included the award as a separate source of res judicata.
I think there may be a reference to it at paragraph 78, if I recall correctly.
Yes.
But the paragraphs that leading up to that, also if I recall correctly, do not appear to address the point.
Well, the oddity is that the learned judge thought that he had done, because he drew that distinction, which the court will doubtless remember in his...
Well, at 78, he does say...
Yes.
He does refer to, by reason of the existence of a prior domestic arbitral award or judgment, but that is not the paragraph with which they agreed. Yes. They agreed with the comment of the French state.
Yes.
I therefore agree with the French government's observation that the EU legislature intended to regulate exhaustively the issue of res judicata by means of Article 3 and 4, thereby excluding the possibility of recourse to the concept of public policy in that concept, in that context. And that's a rather different thing.
Well, perhaps, my lord, I'm. If I can start with the premise that what we've got to look at primarily is what the judgment says.
Yes, I agree.
And bear in mind that the learned judge thought that, at least that the Advocate General had dealt with both aspects of the question. I think it's important when considering this issue, one has to articulate precisely what the issue is. And it is whether public policy in Article 34.1, which is referable to national public policies, but as I've shown you, the court, subject to European limits of public policy, i.e. those limits which are prescribed by European law and by the Court of Justice. It's not every aspect of national public policy which falls within public policy in 34.1. And there also has to be a manifest offence against public policy to an unacceptable degree. So it's not just that it's got to be a European public policy with a subset of national public policy, possibly the other way around. But it's also got to be one where there is an unacceptable degree of departure. It's such that enforcing a relevant judgment would stick in the craw, for incoming judgment, would stick in the craw of the national court. And what both the AG and the Court of Justice have done is, I would respectfully suggest, when one reads the judgment fairly, and indeed the opinion fairly, have said that res judicata is not an available European public policy that would fall within Article 34.1. Much indeed, as Jennard had said in 1968, that it's just, it may or it may not be in any particular nation state that res judicata is configured as a rule of public policy rather than a rule of principle, a rule of law which derives from considerations of public policy, which is a different concept.
Mr. Young, can I just ask about paragraph 77 of the opinion, which is the paragraph that is referred to?
Yes.
And the reasoning, as I read it in that, towards the end of that paragraph, the court ought not to adopt a broad interpretation of Article 34.1 that would limit the effectiveness of paragraph...
Hang on, I'm sorry, my lady.
Yes.
Is this 77 of the judgment?
No, of the opinion, which is the paragraph...
Yes, so I'm sorry, I was just looking at the wrong...
yeah.
Yes.
So I'm on page 22 of the hard...
Yes.
Of the hard copy.
Sorry, I just...
The last sentence, which is strikes me as the nub of the point, shouldn't adopt a broad interpretation of Article 34.1 that would limit the effectiveness of paragraphs 3 and 4 or facilitate any circumvention of the conditions laid down in those paragraphs.
Yes.
Now, both of those paragraphs refer specifically to judgments.
Yes.
Not to arbitral.
Indeed.
So I want to understand I think you're making a rather broader submission than I'm immediately getting.
Yes, I think I am. I think that's right. I would if I may respectfully suggest, I think if you're going to ask me, do the Court of Justice say in express terms, issue estoppel arising out of the award, I would agree that they do not do that. What I do suggest is that it makes absolutely no sense to read the judgment as somehow permitting award-based res judicata to fall within public policy. It would be a completely irrational reading of the judgment. So one shouldn't read the judgment necessarily mechanically. One should read it, as I'm sure you will, intelligently. And that involves, among other things, looking at what the Court of Justice have held in relation to questions 1 and 2, because they reflect upon the true impact of the judgment, dare I say it, in its entirety. So could I ask the Court to look at, to go back to paragraph 45 in the judgment. Which starts with the acceptance of proceedings for the recognition and enforcement of an arbitral award are therefore not covered by Regulation 44, but by the national or international law applicable in the member state in which recognition is sought. That's quite clear. So the court accepts that as a premise. Then one goes to 57, where they start...
I'm a bit behind you. Can you just go back
I'm sorry,
to 45? I need to... Sorry. 45.
I'm sorry, it's page 33. That was my fault.
No, it's not. It's mine. Proceedings for the recognition and enforcement are therefore covered, not by regulation. Yes, okay, sorry, I've got it.
And international law would be, as my Lady Justice Andrews pointed out, governed by the New York Convention.
Right.
On that, I would just pause just to note that the New York Convention requires the existence, if one is going to enforce it, requires the existence of an arbitration agreement between the parties. And of course, that's the one thing that could never happen in the present case. There is an arbitration construct, but not an arbitration contract. So one starts with the premise that the Court of Justice were fully aware of the distinction between arbitration and the regulation. And it would be wrong to read it as being that they were somehow in ignorance of it. Then one goes to paragraph 57, which is at page 34.
Which bundle is this, sir?
I'm terribly sorry. This is in the authorities bundle tab 1. Sorry. Do forgive me. Paragraph 57. Mm-hmm. Having spoken in paragraph 55 about the objectives of the regulation. And then 57, it says, it should be noted, it should be added, that mutual trust in the administration of justice in the European Union, on which, according to recital 16 of the regulation, the rules laid down in that regulation concerning the recognition of judgments are based, does not extend to decisions made by arbitral tribunals or to judicial decisions entered in their terms. So it's pointing out that the essence of the operation as between member states of the regulation is that of mutual trust, and that is lacking with arbitration. Then we go to 58. Which says, it follows that an arbitral award can, by means of a judgment entered in the terms of that award, produce effects in the context of Article 34(3) of the regulation, only if It doesn't infringe a right to an effective remedy and guaranteed by Article 47, and enables the objectives of the free movement of judgments in civil matters, and so on. So the limit of the availability of arbitral awards is distinctly limited before in relation to the court's thinking by reference to the effectiveness principle and the objectives of the free movement. So one has to see that they are confining the availability quite markedly. And then 50...
I just don't completely understand that paragraph. I mean, maybe I'm being stupid.
I'm sure you're not. An arbitration award...
It's following from mutual trust. So mutual trust and the rules laid down in the regulation concerning the recognition of judgments does not extend to decisions made by arbitral tribunals or
Correct.
Judgments based on them.
Correct.
Okay.
Well,
then it follows from that an award or a judgment based on it can produce effects under 34.3, in other words, be recognised as a judgment, only if it doesn't infringe Article 6, I'd prefer to say, right of fair trial, yeah?
Yes.
And free movement in civil matters,
and
mutual trust,
and effectiveness of the remedy.
Effectiveness of the remedy.
It's the underlying premise of the whole structure of the regulation is that all courts are trusted to administer their national laws fairly and properly and in accordance with the public policy precepts, if you like, of all other states. So that Member State A's court does not need to ask if Member State B, with an incoming judgment from Member State B, has got the law, its local law, right, or has administered it unfairly. It doesn't look at the substance of the judgment, and that's Article 36. You just don't look at the substance of the judgment at all. Member State A trusts Member State B to have got it right. Now, you can stop it. It's importation. It's automatic importation, and it should be automatic. Only if there's an irreconcilable judgment, and we've got the answer on what is an irreconcilable judgment, or there is a manifest offence against public policy of the incoming state. So, thus, for example, if I may, just to give some rather crude examples, perhaps, but outside the concept of res judicata. Let's say a contract to enforce a judgment of a foreign revenue authority, which is then sought to be enforced. That would be contrary to the public policy of England to enforce a foreign revenue law. That would be offensive. I say that. I see my Lady Justice.
Well, just because the EU has specific, it's probably not the best.
No, you're probably no. Then, yes, or a judgment on a contract for the sale of one's daughter into employment amounting to slavery, for example. That would stick in the craw of any enforcing court, even though the court in, I don't know, Hungary may.
But what paragraph 58? We're on paragraph 58. That's getting specifically at arbitral awards.
Yes, it is.
Is another way of reading it to say that, might be to say that the court is saying that in the event of any form of conflict, broadly, between arbitration and the regulation trumps the arbitration
I
system.
think
is
that's...
Is that a crude way of putting it?
Is it a crude way of putting it? It's a... I wouldn't say crude. It's a binary way of putting it, I think. But it is right that so far as the regulation is concerned and enforcement as between courts, the answer is arbitration is outside, and arbitration cannot stop enforcement under the regulation as between member state courts, unless there is an irreconcilable judgment. And
but an arbitration judgment is not irreconcilable unless it could have been decided in the jurisdiction itself.
It could have been decided exactly, yes. And so
or there's a race to this alibi pendens.
Yes.
How does that work?
It works on the basis that
I mean, if you're right, sorry, if you're right, then why didn't it just say expressly when it was answering question 3? So obviously, it can't possibly be a res judicata under Article.
I'm going to say that is obviously what they said. They just didn't actually say it. I don't get me wrong. If you're looking for words, say.
No, we won't find it because we looked carefully.
Yes, we've all looked carefully.
Another way of looking at it, Mr. Young, is they didn't say it deliberately, because that was not what they intended to say.
That would be, I think, that would be simply irrational.
Be irrational.
Irrational. I would say it was irrational for a number of reasons. But can I, before I turn to those reasons, can I just show you the balance of the judgment in questions 1 and 2, so that I can then demonstrate the irrationality of that reason?
You know, after 58, I've just been reading on, after 58, they go on to explain their 2 points.
Yes.
2 limbs as to the exception to it being a judgment. But the problem you've got is you've got to explain why judgment is to be interpreted in Article 34.3 as meaning or award, when awards are outside the whole...
With the greatest of respect, that's not the way I put it. The way I put it is that public policy in Article 34.1, construed in the restricted way that it has to be in accordance with the limits of European law, does not extend to res judicata at all. So that a particular member state may or may not regard res judicata as a matter of its national public policy.
What about extending to a national public policy that arbitration awards have to be respected and are outside the regulation and are something important to national public policy?
Because that is not within the meaning of public policy in Article 34.1 as a matter of European law.
Well, the Advocate General says that it's not for the European Court to say what national public policy is.
No, and that's absolutely right.
It can only review the types of public policy.
Well, yes, I showed the court yesterday where the Court of Justice said national courts have the entitlement to look at their own public policy, but there are limits on the extent, that's the word they use, that there are limits on the extent.
He said he says you can review the limits.
Yes, which comes to the same thing, that you review the limits as of the national public policy.
The point I'm putting to you, Mr. Young, is that that's not what this decision was about. So the decision is not a decision on reviewing the limits of public policy under Article 34.1. Now, if it were, I mean, if we were still in the EU, you might well say, well, the correct course for this court is to send it back to the CJEU and say, look, we've got a judgment we don't completely understand. Can you tell us what you meant?
And that would be a perfectly legitimate, would have been, subject to the public policy of the UK now being to reset the relation, but that's another matter.
We obviously can't do that, but is it not in the circumstances for us to do the best we can?
It is. I would absolutely endorse that, to do the best you can in accordance with the binding judgment of the Court of Justice. And I'm going to show your Lordship, I hope, that it makes absolutely no sense. I said it was irrational in answer to my Lady Justice Andrews, and I maintain that it is irrational to read this judgment of the court as permitting public policy to allow an award to operate as a regulation-based bar on enforcement.
Is it irrational to read it as a decision by the CJEU to leave that topic well alone?
No. I'll tell you why, my lady. And I do suggest that it is bizarre. That the Court of Justice was, as I hope I've shown you, to give a judgment on the interpretation and application of Article 34, 1 and 3. To give a judgment which was of assistance to the referring court in the instant case, and you can see that it was seeking to do that very thing, to give assistance. And, importantly, did not send out the wrong message. You'll remember that criterion in what the jurisdiction of the court was directed towards. It is bizarre and irrational to think that the court did not consider that it had given a completely inadequate and incomplete answer, which was of no assistance at all to the questions posed, and which actually undermined the answers to the questions posed. That they said nothing about an award, and if an award had remained within public policy, then everything else they said in answer to questions 1, 2, and 3 would have been entirely irrelevant, not of assistance, and importantly, sending out the wrong message.
Well, not necessarily, because it still leaves would still, on that hypothesis, leave it to the National Court to determine whether public policy did require.
But that was the very question which the court had been asked.
But the court can't answer questions about national public policy.
It can be asked about questions on the extent to which public policy should be interpreted in Article 34(1). That's what they were doing. It is bizarre and irrational to think that the CJEU countenanced that the Schaff Award could and did fall within the public policy embrace without so saying, in giving assistance.
No, I mean, nobody's saying it said it did fall within the public policy embrace. It's just saying it didn't say it didn't, and therefore it's a matter
I
of
agree.
I put it to you a few minutes ago that
Yeah.
it adopted a completely neutral position on that point. In other words, it deliberately didn't answer that part of the question, and it left it to us.
Well, the bizarre thing about that is that they were plainly trying to give assistance for the disposition of this case, which was of assistance and which did not send out the wrong message. To have done what they did in questions 1, 2, and 3, but not said, oh, by the way, what we've said is completely irrelevant because we're not telling you anything about the award and you can do what on earth you like with the award.
Well, perhaps your best point is, I think using the words bizarre and all those other words.
Yes, I'll back away from all
I
of
think
it.
your best point is it would be strange if they left this out of account and left you a loophole, a means of escape, or left the club a means of escape that was clearly put in the third question and not answered. It looks more likely, you would would say, that it's encompassed by the limits of the Article 34(1) public policy as a matter of EU law.
Yes.
That they were saying, because reading it fairly, you would say, looking at it from a sort of, you know, well, you may go so far as to looking at it rationally. It obviously didn't intend to give the club a free hit by relying on the arbitration.
They were looking at it. Let's use the word intelligently, as I'm sure the court will. They were trying to offer assistance for the disposition of the issue.
I mean, I think it is a clear question. I mean, I raised it with you because it seems to me to be a clear question. And as so often when one's trying to interpret decisions of the Court of Justice, they have their own language.
They do.
And we need to understand it. I mean, fortunately, some of us on this court have spent many years learning that language. So, you know, we may be in a good position. But I see your point.
It's much like the sort of argument that one encounters a lot is, if Lord Bingham really meant that, he would have said so.
Lord Bingham.
But he usually did.
He usually did.
And that would be the strength of the point, that Lord Bingham would usually, I chose him on a proper basis. You would expect a court that was trying to render a decision which allowed a jolly big exception, which would render everything else that was set out in the judgment irrelevant. They would have jolly well said so, just as Lord Bingham would have jolly well said so.
But you see, if what the helpful assistance is designed to do is to delineate the bounds, if you like, of a system for recognition of judgments as opposed to arbitral awards.
Recognition of an incoming judgment,
yes.
Can it be stopped in accordance with the effectiveness principle and the objectives of the regulation by an Article 34 means, which operates simply as a matter of national law, because a particular national law categorises res judicata, for example, as public policy, whereas another state may not categorise it as a public policy. They may say it is a principle of law derived from considerations of public policy. And one has to bear in mind the demands of the CJEU that 34 as a whole is to be interpreted strictly. So if there is doubt, then the answer is it isn't available. It has to be such that there has to be an offence against national public policy to an unacceptable degree. Now,
sorry, just for my benefit, where do the words "to an unacceptable degree" come from? Because they're not in Article 30. Is it clearly?
It's in one of the authorities that I did a whistle-stop tour through, and I momentarily.
I'll find it. But it's not expressed.
It's not expressed in the regulation, but I'm sorry.
Yes, it might even be in Genard actually. You showed us Genard yesterday.
Yes, I think I did, but it's in.
It's in Crombach.
Thank you very much. Yes.
It's in what?
It's in Crombach, my lord, which is the decision which talks about the limits on national public policy.
Yeah. Thank you.
Under 34(1).
Sorry, Crombach.
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 Oh, how do you spell it?
Krombach.
Crombach.
It appears elsewhere as well, but I'm sorry, I didn't offer Lady Justice Falk much assistance there. It just, I'm afraid,
I've got the answer.
It was. And what we do have expressed in the regulation is the word manifestly.
Nice.
So if it's a matter of fine debate, then the manifest offence is not enlisted. So I do suggest that on a fair and intelligent reading, not a non-mechanistic reading of the judgment, it makes absolutely no sense that they contemplated that res judicata was available as a public policy defence under defence of, against enforcement outside 34.3. And they say 34.3 deals with res judicata of whatever character. And the only character that is permitted is judgments. And that, of course, is precisely why Mr. Justice Hamblin made the Section 66 judgment that he did. Because, as I indicated yesterday, if the award was an answer in itself, then there was, under 34.1, then there was no relevant utility, no necessity to make the Section 66.
Well, Mr. Justice Hamblin might have been forgiven for not being able to predict 7 years of absolutely tooth and nail litigation and its outcome, including the decision of the Court of Justice and the Advocate General. But yes,
that's why I say there is no issue estoppel arising out of his judgment as well.
We've got that point.
Yes, I thought
it's paragraph 37 of the great case of Bambursky and Krombach, with which I have now become familiar, thank you. And it says, recourse to the public policy in Article 37 can be envisaged only where recognition or enforcement of the judgment delivered in another contracting state would be at variance to an unacceptable degree with the legal order of the state in which enforcement is sought, inasmuch as it infringes a fundamental principle.
Yes, and that is repeated in the later judgments, of which I think I read you at least one, if not two.
It's a rather clear statement.
Yes. And one does find, as the court will, with its familiarity, there is quite a lot of rehearsal of prior ECJ, CJEU judgments as a sort of recital in the judgments. It's dealing with what would otherwise be regarded as a lack of precedential character. But one goes on to paragraphs 60 and 62, if I may, of the judgment of the Court of Justice, and that's at page 35. And it's perhaps here that one can see that to construe the court as leaving open the possibility of an arbitral res judicata is very difficult to fathom. At 60, they say, as regards first the relative effect of an arbitration clause included in an insurance contract, it is apparent from the case law of the court that a jurisdiction clause agreed between an insurer and an insured party cannot be invoked against a victim of insured damage who, where permitted by national law, wishes to bring an action directly against the insurer in tort, delict, quasi-delict, before the courts of the place where the harmful event occurred. Now, a jurisdiction clause can actually embrace an arbitration clause. It's an allocation of a jurisdiction to arbitrators rather than to courts. And they're talking about the relative effect of an arbitration clause. It's apparent that, as it were, a contractual deal imposed by insurers, which it would be, imposed by insurers as against their assured party, cannot be invoked against third parties who suffer damage and have a direct cause of action.
Well, that's more or less what they say in paragraph 61, isn't it?
Yes, and I was going to...
extension of Assenthal.
Yes, and it follows that to avoid that right of the victim being undermined, the victim here is Spain, a court other than that already seized of the direct action should not declare itself to have jurisdiction on the basis of such an arbitration clause. So it's saying you can't use an insurer's choice of jurisdiction or arbitration to evade the protections given to injured parties under the regulation. And it is evasion, not avoidance.
But it says a court, other than.
My lady, that is a self-fulfilling statement. I quite agree. It says the court, but it's saying you can't, by having a choice of jurisdiction clause in a policy, impose that upon an injured third party who is not a party to the contract itself. That's what they're saying. And it makes no sense, if I can put it that way. The relative effect of the arbitration clause.
But I think the logical consequence of what you're saying is that it's somehow wrong to arbitrate in that situation. You shouldn't even kick off the arbitral process.
And what it's saying is that the party who's the injured party is not bound by the arbitration clause and shouldn't be put in a position as if they were bound by the arbitration clause. That's what it's saying.
I think yes and no. It's the party who is in a position of the injured party cannot have his rights, which have been permitted under the regulation and under the national law with a direct action, cannot have those limited by a jurisdiction choice, whether it's arbitration or court, in the contract as between the insurer and his assured.
In other words, he can't be prevented from going to court in his own state.
Correct.
By reason of an arbitration clause.
He may, under a national law, be bound by the arbitration clause.
That's the very point I was going to.
Well, I could see it on the horizon, but it's not, as it were, it's not an exclusive jurisdiction. It's binding, but it's not such as to render his proceedings in the court.
Well, you can't get an injunction to stop him going to court, basically, and you can't then say at the end of the day you shouldn't have gone to court. But it doesn't resolve the question, does it, Mr. Young, as to what happens when you get two inconsistent decisions, one in the arbitration and one in the court?
And no, but the regulation, as between states where the courts have a mutual trust for one another, then I can't remember who said it. The regulation trumps arbitration.
I mean, we are getting to the point of how many angels can stand on the point of a needle about a paragraph in the judgment that is not actually addressing particularly the question we're considering.
I think even St. Augustine would not say that, yes.
So, I mean, it seems to me that you need to probably rest unless you've got some more substantive points to make on your submission, which I put back to you a few minutes ago, which is that it absolutely makes no sense to think that they left this out and that it obviously must be taken to be that Article 34.1, as a matter of EU law, includes res judicata of all kinds, arising not only from Section 66 judgments, but the arbitration that gives rise to them. That was the question that was asked. They may not have been very clear in answering it, but it's obvious what they meant. And in those circumstances, we would be, you would say, falling outside the terms of the binding judgment if we didn't give effect to it.
That's it in a nutshell, my lord. Yes.
And I mean, it's either right or wrong, and no doubt Mr. Hancock will tell us shortly why it's wrong.
Yes. But if I think I'm repeating myself to say that they were obviously trying to give assistance, and if by not mentioning it they failed to give assistance and actually gave the wrong message, then they were doing precisely the opposite of what they were seeking to do and were authorised to do, and plainly thought they had done.
And it's not for us to question what they wanted to achieve.
No, but I think one has to bear in mind also, this is a parallel point, that one of the principles of UK public policy at the time when we were blissfully still members of the European Union was respect for the effectiveness principle. And the effectiveness principle required respect for and giving effect to the judgments of other member state courts. Now, if by having a domestic award one can, under 34.1, prevent the effectiveness principle from operating, then that public policy of respecting the effectiveness principle is defeated.
Well, that's a slightly circular.
Oh, I agree. Yes.
Isn't it really whether Article 34 applies? Isn't that?
Yes, yeah, absolutely, absolutely. It's you.
If Article 34 applies, you don't get to the effectiveness principle. If it doesn't.
But in order to see whether Article 34.1 applies, you have to.
No, it's. I'm sorry, I disagree with that.
Then I'm wrong.
It's a matter of analysis. That can't be right.
Then I'm wrong. But in my respectful submission, the effectiveness principle must form a part of English public policy.
Of course it does. The effectiveness principle comes in once you've decided that the judgment should be recognised and enforced. And once you decide it should be recognised and enforced, you can't do anything to stop it from becoming effective.
No, my lady, with the greatest of respect, I would, if I may, take issue with that the effectiveness principle, you say, comes into operation only after you've decided that the...
well, in accordance with the regime.
Yes,
I say
the effectiveness principle is part and part of the consideration of enforcing the incoming judgment in the first place. Whilst I'm sure I'm
no, I see the point.
it's not the point that I think your ladyship was putting to me. I think it's.
No, I see what you're saying. You're saying if you're looking at the construction of Article 34.1, you've got to take into account the fact that if you take construction A, it will mean that the judgment is not effective, and that is contrary to the effectiveness principle.
Exactly, that's it. And when one sees at paragraph 60 and 61 of the judgment, they've clearly laid down their markers as to where they think the right answer should lie. And this comes back to the very neat summary by my lord as to what my argument is. But I say you really have great difficulty in understanding the answer to the third question if it permitted the arbitration award to create a res judicata which was immediately of an objective frustrating effect. The objective being that the rights of injured third parties against insurers.
Well, you say if you look at the consequences in paragraph 63, that those consequences apply equally if the arbitration itself prevented the recognition of that judgment.
Exactly, yes.
That's really that's the high point of your argument, isn't it? You're saying, as a matter of logic, if you follow through the thinking in that passage from 60 to 63, you say the same, if you would accept that a judgment would do that, then a fortiori, the arbitral award itself.
Yes. Once again, the proposition that comes from the bench is better than the way I put it, but that's exactly the way I would like it, my submissions to be configured. Bearing in mind that behind all of this, we've got Gennard who says public policy has got to have a pretty limited effect, and that's been tattooed into European jurisprudence since 1968, even before I started to study law, which is a long time ago. It doesn't mean that the public policy exception in 34.1 isn't available in cases where it would stick in the craw of the enforcing court to do it. But that's essentially it would stick in our craw to enforce this judgment, because there's something inherently awful about it. Not about the substance or the substantive reasoning, but about the content.
The result.
The result. Yes. I mean, for example, I off the top of my head,
Well, you
I
came
thought
up with
of
a modern slavery suggestion, and I think we can all come up with examples.
yes, a contract to smuggle vodka into Canada, which then generates in England that would be met with Foster and Driscoll, but in Hungary, who knows, it may be enforceable. That would be offensive to, that would stick in the craw of the English.
Picking on the Hungarians.
Well, I don't know why I'm picking on the Hungarians. Well, I do know why. I don't know why I'm picking on the Hungarians.
Let's move on.
It's another court, Transylvania, a member state, Transylvania. But there is still plainly a lot of scope for public policy, but it isn't a public policy which embraces res judicata, which, for one reason or another, the draftsman of the regulation and the CJEU have said is covered by Article 34.3, and it relates only to irreconcilable judgments. And the reasoning which got to that in paragraph 1661 is plain to see. So I would suggest that a fair reading of the judgment simply cannot permit of the conclusion that the Court of Justice thought that res judicata arising out of an award was available as a regulation reason for not enforcing a perfectly sound regulation judgment. So that's really really it on the question of the so-called res judicata, or issue of stock arising out of the award. It may be that, having heard my learned friend, there may be other points, but at the moment I hope I've set out my stall, and it's for you, poor things. You've got to grapple with what is a very difficult question, and particularly as in the present context, where the correct enforcement and application of the withdrawal agreement and possible infringement proceedings can be engaged, and dare I say it, in the context of resetting the relations, it's a very sensitive question that the court has to approach, and I don't envy you, I must confess. Now, but that I think deals with the award res judicata, so-called. Can I go back to...
I mean, I just see Mr. Hancock getting ready to rise to his feet, but on my timetable it tells me that we'll get Miss Norris first.
Your Lordship is quite right. I was getting ready rather too rapidly. Yeah.
Always be ready.
I've known my learned friend a long time. He's always ready. But a couple of points, if I may. One oversight, and I yesterday when I showed your Lordship, your Ladyships, the authorities on whether national courts have a jurisdiction to consider the vires of the CJEU, I omitted to show you the opinion of Attorney General Sanchev in the AB case, which is at bundle, I should think 5, at tab at 101 at page 2737. I won't take you to it now. I think we set it out in our skeleton, but I just overlooked showing it to you. But it's just another nail in the coffin of the jurisdiction of national courts to review the vires. If I can deal with it relatively quickly, if the jurisdiction of the national courts did extend to considering vires, I did submit that there was no excess of the vires, as I've shown you that the passages in Bromberg and Fenger, which indicate that the court has perhaps a more flexible jurisdictional approach to giving the right answer in relation to the right provisions of European law on the facts stated. So, and what they did here was giving an answer to the question posed, which was a nuanced answer, but it was an answer which was endeavouring to be of assistance to the referring court. And the learned judge said that he had refused what he calls the two questions arising out of Assenshaven and Respondent. Now, I must respectfully say that that is an untenable position, because when one looks at the legitimate reference, which is at core supplementary bundle, tab 11, page 86.
The actual order is at tab 13, I think.
I beg your ladyship's pardon?
The actual order for reference is at tab 13.
Yes, yes. It's I said the order for reference is the actual reference is what you've actually got to look at. But even when you look at the judgment leading to it,
I see.
You will look in vain for any express exception other than that which appears at the end, which is at page 103, paragraph 53. Where the learned judge said in his judgment, although it didn't appear in the reference, I should also add I wasn't persuaded that the other question as formulated by Spain in relation to Article 34.1 human rights point was necessary or suitable for a reference. The issue is primarily one of English public policy, and that's how it was dealt with in Smith and Huertas. That was the case where Mr. Justice Cook held that if the European Court of Human Rights has given an answer, then that's good enough. The point is that was the only occasion on which the learned judge made an express exception to the questions referred. He didn't make an express exclusion. And I don't know how many times I've read this judgment. It is, I cannot discern any statement saying that he is excluding from consideration the objectives of the regulation in the construction of Article 34. And one may say, as Sir Christopher Stork would have said, the expression of the one is the exclusion of the other, that when you say that you're not referring the human rights, then that's limiting whatever else is not referred. But when one looks at the actual reference, which is at page 128, tab 13, as my lady points out, one looks even more in vain for any express or implicit exclusion. And perhaps if one looks at page 141, where the learned judge deals with the reasons for the reference, he says, as to the first question, paragraph 48, the issue, sorry, I'll let, there's nothing so awful as being read to when you haven't got the bundle.
I've got it now, thank you.
Are you there, Melody?
Yes.
Right. First question, the issue is whether the requirements described in Solo, that the decision in question must emanate from a judicial body of the relevant member state and must decide issues between the parties, meant that a Section 66 judgment is not a judgment for the purposes of 34.3. In particular, the question is whether a Section 66 judgment qualifies as a, quotes, judgment, where the national court has determined disputed issues between the parties, but has not itself heard all the substantive merits of the dispute. And of course, that is in a sense, the open door on the nuanced answer that the court gave. And he then just says, there is no decision of the CJE which has expressly decided this precise point. Mr. Justice Butcher considered that he could not be completely confident of the answer, and so on. And then at paragraph 49, the issue is whether the judgment falling outside the material scope of regulation by reason of the arbitration exception can prevent recognition and enforcement of a regulation judgment from another member state pursuant to 34.3. And then that was the reason. He says, well, Hoffman and Krieg deals with the case of, as it were, a non-regulation judgment in the enforcing state being available to meet a regulation judgment, but it's still a legitimate judgment. And then he said at 51, the third question, the issue was whether on the hypothesis that Article 34.3 of the regulation does not apply, it was permissible to rely on Article 34.1 as a ground for refusing recognition or enforcement of a judgment of another member state on the basis that it violated the principle of res judicata by reason of a prior arbitration award or a prior judgment entered in terms of the award. And one doesn't see anywhere there any exclusion of the sort that the learned judge sought in his judgment to depict as being a refusal to state a question. But one, and over the page, page 52, it's a possibly relevant consideration, is in the circumstances, Mr. Justice Butcher considered it was appropriate to exercise the discretion to make a reference as the relevant facts were not in dispute. So the Court of Justice knew that all of the facts stated in the reference were all of the relevant facts. And they were not in dispute. So they could then give a dispositive answer, which was of assistance. And in the formulation of the questions, there is not a hint of an exclusion. So I would suggest that the reference itself did not manifest a refusal, in contrast to Turing Tours, where there was not only an express refusal to refer, but there were reasons were given for that express refusal. And in the context, admittedly, of a point arising in relation to the fair procedure, it's probably important that the court should have in mind the letter at page 145 of this bundle, sent by Messrs. Ince & Co., who were then acting for Club, where they wrote to the Court of Justice. And at 146, at paragraph 5b, one may see a certain amount of linguistic confusion. I don't think there's any intellectual confusion, but I rely upon that in my reading of the judgment. 5b, if an arbitral award is capable of being a relevant judgment for the purposes of Article 34.3, the court may wish to set out the criteria that national courts should apply when determining whether, in any particular case, under any particular national legal system, how a court registers or renders enforceable an arbitral award renders the resulting judgment such a relevant judgment. So the club itself said the court may wish to set out the criteria. Well, that's exactly what the court actually did. The fact is that they didn't like it is just unfortunate. They'd done that. And then over the page, 147 at subparagraph E, this was in the context of points that the club wanted to have an oral representation for the court and wanted more time for it. And this is quite important. Some written observations seek to raise issues which have not been referred, such as the question whether the Spanish judgment and the English judgment are in any event irreconcilable, whether Assenshaven has any bearing on these issues. Given that these points were not raised by the questions referred, the association has not yet had the opportunity to make submissions on them and respectfully submits that it should be given the opportunity to address the court as to why these issues are irrelevant to the questions referred and, if necessary, explain why they are misconceived. But so the Court of Justice was told by INS that these points raised had not been referred, and then they asked for time to deal with them as to show why they were misconceived. So they were given time. They were given, in fact, nearly twice the amount of time available. Admittedly, it doesn't seem very long. But
I mean, is all this really going to add to the price of beans, Mr. Young? I mean, at the end of the day, we've got to decide what the Court of Justice said.
It only adds to the price of beans if the price of beans is relevant to the question of the learned judge's consideration of the vires of the Court of Justice. Yes. And this deals with procedural unfairness. It's just laying the groundwork for procedural unfairness. But otherwise, the price of beans has not got anything to be engaged. Although I would just refer to page, while I'm doing so, page 153, where the court made it, dare I say, blindingly obvious, and under Annex 1, in their replies to the first and second questions, the interveners at the hearing are requested to focus their arguments on whether the objectives underlying the regulation require an order of national court to be excluded in substance and so on. So it could not have been expressed more clearly that the Court of Justice was wanting a consideration of the objectives of the regulation, which is what they did. However, I will say no more on that, as there are no relevant beans in that inquiry. I do suggest, therefore, that the learned judge was quite wrong to say that even if he had jurisdiction to review the vires of the Court of Justice, that the Court of Justice exceeded those vires and acted improperly or unfairly. I've got a note of the observations which you might, of various observing parties that you might like to have. Would you like to have the notes of a note of the observations or not? I would suggest that the letter of the 23rd of August really rather neatly deals with it. I can give you the reference.
This is observing parties to
the
CJU.
Yes. If you want the references, I can give them to you.
It's not in the bundle.
Sorry. Yes, they are in the bundle. It's just the references.
Give me the reference. Yeah.
Would you like them?
Yes.
Yes. Right. Germany. Bundle 5, 1259, 1263, and 1262 and 1263, looking at paragraphs 9, 20 to 28. Poland at bundle 5.
How many of these are there?
4.
Oh,
I mean, no.
You can put them in.
The beans have been counted.
Send them in an email.
Yes, I will. The point is that the club was well aware of what was being said. They wanted extra time to address it, and they were given extra time, and what they actually did with that time is lost. There's never a record. So
They knew what was happening and it happened.
they knew what was happening, and it happened, and they didn't like it.
Or it didn't happen, depending on what we did.
Yes, yes. In my submission, the Court of Justice did precisely what they were there to do, and it didn't trespass upon the facts of the case because the facts of the case were undisputed. And we know, because I've shown you the Broberg and Fenger, that sometimes the Court of Justice can engage more facts that if the urge comes upon it. But in this case, it didn't. It relied only upon the facts that set out in the reference. So it didn't exceed its vires in that way either, and it didn't exceed its vires on procedural fairness and that particular row of beans. I think whilst I'm dealing with it relatively briefly, there's one reference which I will ask the court to look at, which is the Diageo decision on which is at bundle 4, I would imagine, from my lady, at tab 81. And I will be quite quick. It's quite an important judgment, particularly, I think, in the context of the human rights issue. And it's tab 81. And it may be a very good...
2205.
Sorry, 2205. I'm sorry, yes, thank you. It was in many ways an extraordinary case because it involved an application by Diageo in relation to, by Diageo, who is the trademark proprietor, in relation to a consignment of Johnny Walker whiskey, which had been imported into Bulgaria from outside the EE area. And it was seized in Bulgaria, and then the seizure was lifted, and a judgment was entered by the Bulgarian court, which was then to be enforced in Holland. And it was said in Holland, the Bulgarian court has offended EU rules. So the incoming court is itself an offence to EU rules on patent infringement. And the Court of Justice said, that's as may be, but it's not a ground for resisting enforcement of the Bulgarian decision.
So paragraph 68 at 2235 makes that
Exactly.
clear. But
And I go back to
rather special
64
case,
as well.
Not quite our case.
No, but what it, well, it's also paragraph 64, if I can just mention it. But it shows the extent to which public policy is very limited. It's not even public policy that the EU's own regulations...
Its own public policy.
Its own public policy, let alone... which, and of course, is by definition the public policy of every major member state. Blah, blah, blah. So it's just a very powerful case exhibiting the very narrowness of the public policy exception. That's why I'm showing it to your lordship and your ladyships. If you give me, there's an element of tidying up in my submissions. If I can turn to the question of whether the judgment of Mr. Justice Hamblin created an issue estoppel precluding as it were, the current argument based upon the regulation objectives. And for that, the judgment of Mr. Justice Butcher, which is at page 265 of the core bundle,
So you're in Butcher 2023, right?
I'm sorry, my lord.
You're in Mr. Justice Butcher's judgment, what I call the second judgment.
Yes, the 2023 judgment, not the human rights. Yes.
Which paragraph?
And paragraph 203 is where he states his conclusion on the res judicata, rather issue estoppel emerging from the judgment of Mr. Justice Hamblin. He says, I therefore conclude that there is an issue estoppel to the effect that the jurisdiction allocation provisions of the regulation, in particular lease pendens and insurance provisions, were no good reason for the English Section 66 judgments not to have been entered, because the regulation is not applicable to arbitration. And this prevents Spain from contending to the contrary. Now, so far as it goes, that is perfectly unexceptionable. Yes, it was no good reason for the judgments not to be entered. But Spain is not contending that the judgments should not have been entered. I don't contend, I don't have to contend. It may be that the Court of Justice had a rather more stark view. But what I say is that having entered the Section 66 judgment, the question was then, is it a regulation judgment under Article 34.3? And that was not decided by Mr. Justice Hamblin. And the learned judge himself actually doesn't say it was. Although he does say Spain is precluded from, in some respects, I suppose, presenting an argument which says that it, in response to the suggestion that the Section 66 judgment is an irreconcilable judgment under Article 34.3. So the learned judges intellectual, and there is no greater admirer of his intellect than I, his intellectual analysis fails to distinguish between the issues before Mr. Justice Hamblin and the issue now as to whether the Section 66 judgment is an Article 34.3 judgment. And one goes back to his reasoning. His discussion starts at page 258. And I think it would, at paragraph 175, in my judgment, the Club is largely correct in its analysis of what occurred and its legal consequences. In his submission before Mr. Justice Hamblin, Spain, then represented by Mr. Smooha, put forward two arguments: a Spain skeleton argument for the hearing of the 14th of October, and the transcript of the hearing, especially pages 15 and 21, make clear. Spain was contending that either a Section 66 judgment would not be a relevant home judgment for the purposes of Article 43, in which case there would be no utility in granting it, or it would be a relevant judgment for Article 34.3 purposes, and on the hypothesis that it was the latter, then it would be contrary to regulation principles for the court, for the Club to seek, and the English court to grant a Section 66 judgment. So it's, as it were, the premise of the second argument is that the Section 66 judgment is an irreconcilable judgment, which is the very question now in debate. So the premise is simply that. I'm sorry?
Could you read the next sentence?
Yes. Specifically, yes, I've been asked, specifically to grant such a judgment would disregard the scheme of the regulation, both as to the lease pendens provision in Article 27 and the direct action provision in Article 11. Now, the entry of a judgment, which was a regulation judgment and an irreconcilable judgment, would be inconsistent with the provisions, is not at all the same thing as saying, well, if the judgment is entered, which actually goes against the objectives, is it an irreconcilable judgment under Article 34.3? A completely different point. And and then it's 177 on page 259. It is my view, sorry, in my view, the learned judge says, it is clear that Mr. Justice Hamblin had reached a final decision on the alleged inconsistency with the regulation jurisdictional regime was not a good reason for not entering a Section 66 judgment because the regulation did not apply to arbitration. That's absolutely right. He said, you don't, it falls outside the regulation, therefore the regulation considerations don't apply. This was not simply a decision on the basis that there was an arguable case that the regulation scheme might be irrelevant. Well, it was irrelevant according to the judge. The argument he was facing was that the English court should not enter the 66 judgment at all, and that if it did, and was a relevant judgment, it would subvert the regulation regime because it would prevent enforcement of any Spanish judgment. So, if it was a relevant judgment, once again, it's missing the point. And then perhaps at 183, he says, on the other hand, I do consider that Mr. Justice Hamblin's decision gives rise to an issue of estoppel. As I've said, Mr. Justice Hamblin decided that a Section 66 judgment, or the Section 66 judgment, should be entered, and it was not relevant that the court could not have heard the claims in the Spanish proceedings by reason of the regulation's jurisdictional allocations, including lease pendens and direct action provisions, because the regulation did not apply to arbitration. So, but if you're trying to ask yourself, is this a regulation judgment, that is a different problem. So, can I show you also, given that we are looking for an issue estoppel, and I'm going to start with the premise that estoppels characteristically have to be clear and unequivocal. One thing you will not find is anything clear and unequivocal about the estoppel that is being alleged. Mr. Justice...
Can I just ask you, Mr. Young, how long you are intending to be? Only because I don't want Ms. Nice to sit there and sort of...
I'm just going to show you a short passage in Mr. Justice Hamblin's judgment, and then I'm going to sit down.
10 minutes.
I think so.
Even less.
If that's... Yes, I hope less.
Thank you.
I did say I would try and truncate my notes, and
I'm not complaining. I'm just asking.
Well, you'd have every right to complain.
You would know if I were complaining.
Yes, I think that's possibly. So when one looks at Mr. Justice Hamblin's judgment, which is in bundle 1 of the authorities at tab 2, pages 39 following, and page 63 is the bit.
Which paragraph?
Starting at, well, it's the right-hand column, subparagraph 5, heading 5, should the court grant the application as a matter of discretion. So he, at least, was regarding this, the considerations then engaged, as entirely a matter of the discretion to enter a judgment.
That's because that was one of the issues that he identified at the start.
That's right.
One was sovereign immunity, the other was discretion.
Yes, that's right. But he was approaching it as an issue of discretion. And he considered the two arguments. He then looked at page 64, the consideration by Lord Justice Toulson in the West Tankers case, And he said, I can't see why in an appropriate case the court may not give leave for an arbitral award to be enforced in the same manner as it might be achieved by an action on the award, so as to give leave for judgment. And of course that's exactly what Section 66 does. It's a summary procedure for an action on an award. And once the action on the award is achieved, then the cause of actions, such causes of action as arise from it, are merged. Whether there's an issue of estoppel is another matter, I would accept. And in paragraph 187, he says, there's a real prospect of establishing primacy of the award over any inconsistent judgment which may be rendered in Spain. So he's looking at the real prospect case. And then over the page, no, I suppose just at the bottom of 64, paragraph 189, the defendant challenged the correctness of Mr Justice Beatson's judgment. This is in the African fertilizers case. But I agree with Mr Justice Field that it would not be appropriate to decide that issue in circumstances where any inconsistency is still hypothetical, and it is sufficient for there to be a real prospect of establishing primacy. And of course, any prospect of a Spanish judgment was entirely hypothetical in those circumstances. The defendants submitted, that's Spain, that there are two possibilities. The first is that the Section 66 judgment is not a regulation judgment. That's my case now, and it's been held, and therefore there is no utility in it. The second is that it is a regulation judgment, in which case it would be inappropriate to exercise the court's discretion to grant leave for such a judgment to be entered. So the very premise of question 2 is the premise which doesn't arise now. And then the defendants submitted that it would be an inappropriate exercise of the court's discretion because it would serve to subvert the regulation jurisdiction dispute regime because, and then 2, the subject matter of the enforcement proceedings is arbitration and thus outside the scope of the regulation, and 3, the Spanish court was the court first seized for the purposes of 27(1), and were it not for the fact that Section 66 proceedings fall outside of regulation, the English court would be obliged to stay its proceedings, and so on. Now, in short, the non-regulation nature of the Section 66...
Could you read 192, 193 and 194?
Yes, I was about to do just that. In short, the non-regulation nature of the Section 66 proceedings allows the court to ignore the mandatory stay imposed by the regulation, yet it would assert the status of having issued a regulation judgment in order to trump the judgment of the court first seized. The defendants submitted that such a result is not countenanced by the regulation, and the court should not exercise its discretion so as to encourage such a result. 193, you want?
Yes, please.
This argument assumes that the court should treat the present application as if it was regulated by the regulation. However, this is an arbitration application, and arbitration falls outside the regulation. Potentially inconsistent decisions and a lack of coordination are recognised consequences of the arbitration exclusion. What I made yesterday. As the club put it, why should the court refuse to grant a party the full benefit of an award, which it has, because to do so would run counter to the scheme of a regulation that does not apply to arbitration? In my judgment, as in the West Tankers case, there is clear utility in granting the judgment, and the regulation regime is not a good or sufficient reason for preventing the court from seeking to realise the full benefit of their awards. Just say...
The club, not the court.
Sorry?
The club and not the court.
The club, sorry. Sorry, yes, the club. So he's saying that the full benefit of the awards can only be obtained by the entry of a judgment, which can then operate as an Article 34(3). My learned friend says, no. He's answering the question, if the Section 66 judgment cannot be an irreconcilable judgment because it offends the other objectives of the regulation, and that's precisely what the learned judge did not decide. And it's
With
the,
great respect, that's not what I say.
oh, all right. Well, never mind, you can say it. It's the second half of para 194 that is said to give rise to the issue estoppel. Now,
193.
if I'm sorry, I'm taking this at some speed because the issue is different, and my learned friend will address that. But the point is, it is said that that was a clear and unequivocal final determination of the issue of whether the objectives of the regulation had relevance if the Section 66 judgment were a regulation judgment, which it isn't. And then when we came to the Court of Appeal, there was the point, which I hope I can deal with quite quickly. There was it's in bundle, supplementary bundle 2, tab 10, page 420, and going over to 424 and following. What happened was that time was becoming very tight in the appeal, and the issue of the exercise of the court's discretion came to be considered. And Mr. Smuha, at page 420, going over to 423, put in a note, and it's at 423. It's ground 3, which is the one which related to that issue, and it says at paragraph 8 of page 423, given the time constraints on this court, on this appeal, and given that the matter is not straightforward, the appellants do not propose to pursue ground 3 further on this appeal. By that ground of appeal, the appellants sought to persuade the Court of Appeal that the judge was wrong not to decide now the question whether the English Section 66 judgment could be used by the club to resist recognition and enforcement of a Spanish judgment holding the club liable. The judge held that it was sufficient to decide now that there was a real prospect of establishing that the Section 66 judgment would have primacy over a Spanish judgment. And then it is explained, perhaps at B2, if a Spanish judgment establishing liability is issued, the question of primacy would fall to be considered if and when the appellants sought recognition and enforcement of the Spanish judgment. The appellants are therefore not prejudiced by not pursuing. Now, so they said, we're not raising it now because it's entirely hypothetical and it can be raised at the time when there is a judgment, if there is one, as indeed there now is. And this was ventilated in the Court of Appeal at page 429 in a short exchange between Mr. Smuha and Lord Justice Moore-Bigg, where Mr. Smuha says at para 35, in those circumstances, because this is an issue that would arise if we don't pursue it on appeal, will arise first only if there's a Spanish judgment which is sought to be imported here, and at that point a question of recognition will arise, will fall to be decided then. On that basis there, and on the basis that the judge below only decided in the context of utility, holding that there was a real prospect of arguing that the English judge could primacy, my lord, we're not going to pursue that ground. Lord Justice Moore-Bigg, you'll fight that another day. Exactly so. Lord Justice Moore-Bigg, that seems sensible, if I may say so. Right, thank you very much. This will undoubtedly save time. So the issue estoppel, which my learned friend is now asserting, was one which the Court of Appeal were content to leave over to a time when it became, as it were, real, and there was an imported judgment, which is now. And Lord Justice Moore-Bigg thought it was sensible to leave that over. Now, how one can construe a clear and unequivocal determination of the present issue as to whether the judgment, the Section 66 judgment, is an irreconcilable judgment is, if I may respectfully say so, difficult to discern. There was no issue estoppel. The only thing that Mr. Justice Hamblin decided was that in the exercise of his discretion, he was concerned only with the arbitration exception.
He decided the point was arguable. He decided that the question was arguable, and that was no more. He decided it was arguable, but he didn't actually decide the point. Spain were complaining that he didn't decide the point. They then decided not to pursue that complaint because they could save their powder and shot for another day,
And
which is now done.
And Lord Justice Morbick said that seems sensible. So
Yes.
I would respectfully suggest that that does not give rise to an issue estoppel. So we're not really concerned with whether issue estoppels do or do not form available Article 34(1) grounds. My lady, I think given that I say the issues are entirely different, and given that the Court of Appeal was content to let it lie and await what is now a present hearing, I propose not to make any further submissions unless it would assist, and I see my lord is not encouraging me.
I'm just putting my hands up. I might do that for any reason.
My lord, I've been going through it slightly more than my customary trot.
You've been very helpful,
Unless I can
Mr.
assist
Young, and we will hear you again later.
Hard luck is all I can say, my lords. Unless I can assist your lordship further, those are my submissions.
Thank you very much indeed. Nothing more? Nothing more?
Do you want to? Thank you.
Very good. Well, Miss Norris.
My lord, my ladies, the Commission has listened attentively to the questions that Spain's submissions have elicited from the court, and we have also taken note of the points in this dispute between the parties, which my lordship has indicated would be most worthy of assistance. And given that, if I may open my oral observations by clarifying the nature of the Commission's participation in these proceedings. And I do so because this has a direct bearing on the content and structure of what I shall say. The withdrawal agreement, which is behind tab 17 of Authorities Bundle A, commencing at page 0343. That agreement sets out the arrangements for the orderly withdrawal of the United Kingdom from the Union. And as is reflected in the 11th recital of the preamble, which appears approximately halfway down page 0344, the parties to the withdrawal agreement considered that it would be necessary to include provisions, and I quote, to guarantee the correct interpretation and application of this agreement and compliance with the obligations under this agreement. Now, the legal basis for the Commission's participation in these proceedings is found in Part 6, and Article 162 of the withdrawal agreement is to be found on page 0362. And this specifies that the Commission's right to make observations in proceedings pending before UK courts is directed towards ensuring the consistent and interpretation and application of the agreement. My lord, my ladies, there are two key points that flow from the above. The first is that the Commission is not here in court today to intervene in support of one or other party as regards the underlying dispute between them. The term intervention in European Union procedural law has a very specific meaning reflected in Article 129 of the Rules of Procedure of the Court of Justice. And those rules specify that an intervention shall be limited to supporting in whole or in part the form of order sought by one of the parties. That is not what the withdrawal agreement says. Under the withdrawal agreement, the Commission has been accorded a role analogous to an amicus curiae, to provide observations with a very specific aim, and the term observations in that provision was chosen deliberately to reflect this function. And this also explains the requirement that the Commission inform the United Kingdom in advance when it intends to make such observations, since, like the Union, the United Kingdom is a party to that agreement, and that information was duly provided to the United Kingdom.
But the United Kingdom has never sought to appear
Our understanding is the United Kingdom has never sought to appear. However, the Commission duly informed the United Kingdom of its intention to make observations.
But the United Kingdom, the government is aware of this hearing
The government is aware of
and
this,
has not made an application to intervene, as we would call it.
not that we're aware.
Okay, fine.
The second point that stems from the nature of our participation is that the Commission is not required, and indeed it would not be appropriate for the Commission to address each and every point which arises in the present appeal. And nor is it relevant what the Commission may or may not have pleaded before the Court of Justice on substance in the reference for the preliminary ruling. The Commission, like other institutions of the European Union, the Member States, and we say in this case the United Kingdom, is bound by the judgments of the Court of Justice. And so the Commission is here today to advance submissions to assist this Court in giving due recognition to the binding force of such a judgment. And logically, therefore, no inference can or should be given or drawn from the Commission's silence on any point. Now, we raised this because it was raised by the Club in their supplementary skeleton, and we refer to our response in our supplementary skeleton, in particular at paragraphs 7 to 12. Now, I indicated that the structure of our submissions would be informed by this, and if I may briefly describe that structure. First, I propose to set out our main position, and then I propose to address 4 issues, all of which necessarily relate to the interpretation of the withdrawal agreement. And those 4 issues I have formulated as questions. The first is, which legal framework governs the interpretation of the withdrawal agreement? The second is, what is the relationship between Article 267 TFEU and Articles 86 and 89 of the withdrawal agreement? And both of these points are relevant because of the position that has been advanced, that there is a difference in the situation under the withdrawal agreement as compared with the situation whilst the United Kingdom was a member state. The third question is, can the withdrawal agreement be interpreted as conferring a power on the courts of the United Kingdom to rule upon the scope and exercise of the jurisdiction of the Court of Justice under Article 86 of the withdrawal agreement? And the final question is, how is the term in its entirety in Article 89 of the withdrawal agreement to be interpreted? And my lord, my ladies, this is where we will address points that have been raised yesterday in relation to paragraph 71 of the Court of Justice of the European Union. So if I may turn then without delay to our main position, you will have read our observations, and I do not propose to simply repeat the content of them today. The central issue that the Commission addresses is whether the withdrawal agreement required Mr Justice Butcher to recognise the binding effect of the entirety of the judgment of the Court of Justice in KC 720. Now, this issue arises because of the approach of Mr Justice Butcher when addressing a plea referred to as the Club's jurisdictional ground, as reflected in paragraphs 211 to 213 of the High Court judgment. Now, at paragraph 213, which appears behind core bundle tab 9, page 268.
Sorry, let me just find that. 268.
68.
Yeah.
So in that paragraph, the learned judge concludes that this case clearly raises the issue of whether the CJU has exceeded its jurisdiction and the consequences it has. And indeed, questions of the interpretation of the withdrawal agreement are clearly reflected in Spain's appellant's notice at page
Sorry,
7.
which paragraph are you reading from?
213.
13, thank you.
Yes, 1-3. It's the final sentence. This case raises clearly the issue of whether the CJU has exceeded its jurisdiction and the consequences if it has. Now, our position, which is elaborated upon in part 3 of our written observations, is that Articles 86 and 89 of the Withdrawal Agreement must be interpreted as meaning that the courts of the United Kingdom are bound by the entirety of the judgment. Notably, therefore, the operative part of that judgment, which Mr Justice Butcher held did not have such binding effect. And the reasons we say this are that Article 86 of the Withdrawal Agreement, and if I may take you directly to that, it's back behind tab 17 of the Authorities Bundle at page 0353. Article 86 provides for the continuation of the jurisdiction of the Court of Justice of the European Union to issue preliminary rulings on requests made during the transition period. And we do not understand it to be contested that the judgment in KC 720 is a judgment issued by the Court of Justice of the European Union in exercise of that jurisdiction as expressly conferred upon it by the Withdrawal Agreement. And as such, the judgment in that case has the effect in the United Kingdom's legal order that has also been explicitly provided for in the Withdrawal Agreement. And here I refer you to Article 89(1), which specifies that judgments handed down after the end of the transition period in proceedings in Article 86 shall have binding force in their entirety on and in the United Kingdom.
Seems quite clear.
Hence, we say these provisions of the Withdrawal Agreement, when accorded their ordinary meaning, affirm that the judgment is binding in its entirety, as to the correct interpretation of Union law. And we further say, as a result, insofar as Mr Justice Butcher appears to have reasoned that the operative part and part of the ground in the light of which that operative part must be interpreted could be disregarded, this is inconsistent with the Withdrawal Agreement. And we further say that, for reasons that I'm about to address, it is derived from an incorrect appreciation of the jurisdiction of the Court of Justice of the European Union, as defined in the European Union's treaties and as continued under the Withdrawal Agreement. So then I turn to the first question, the first issue, which legal framework governs the interpretation of the Withdrawal Agreement. And our point here is that Article 86, just like Article 89, fall to be interpreted in the manner defined by the Withdrawal Agreement itself. This is not something which the parties chose to leave open. Article 4.3 of the Withdrawal Agreement, which is at page 0348. Mine tab 17 still.
Sorry, Article 83.
So 4.3, Article 4, subparagraph 3, and this is at page 0348. Tab 17. Maybe it's 03. We had a problem with our numbers as well. 0346, perhaps.
Yes. It's 354 of the electronic.
Well, Article 4.3 states that the provisions referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the general methods and principles of union law. And union law itself is defined in Article 2. Now, we have seen one point raised against this interpretation in the club's supplementary skeleton. It appears to be argued that Articles 86 and 89(1) are not identical to Article 267, and nor are they concepts of union law which necessarily have identical scope. Now, we understand the club to argue that this supports a broader proposition that even were the judgment to have been binding under Article 267, it need not necessarily be so under the Withdrawal Agreement. And this is a point on which the Commission makes the following observations.
Did the judge say that?
The judge reached his conclusions on an alternative basis. the judge submitted first that
So is this one of the respondents' notice points in the club's argument?
it's a point that's been raised in their supplementary skeleton.
Okay, well, we'll ask them when we get there.
But I can be very brief.
Anyway, you say,
We say that on a plain reading of Article 4.3, a provision necessarily need not be identical to that under Article 267 in order to nonetheless be a principle of union law. And we would say, moreover, a preliminary ruling most certainly is a concept of union law, since it's a mechanism provided for in the treaties. And should the court require authority for that proposition, we would simply refer you to Article 19 of the Treaty of the European Union. But perhaps, given that issue may not be as weighty as others, I will move on to the second issue.
right,
And this concerns the relationship between Article 267 of the Treaty of the Functioning of the European Union and Article 86 and 89. And here again, our main point is that the extent of the Court of Justice's jurisdiction under Article 86, as indicated by the use of the term shall be continued, is not narrower than the jurisdiction which it enjoyed to issue preliminary rulings in response to requests made under Article 267. Moreover, the scope of the court's jurisdiction is necessarily informed, and here I mean the scope of the jurisdiction under Article 86. It is necessarily informed by the scope of Article 267, because it is precisely this jurisdiction which is being continued. Now, we take careful note of the parts of the judgment as replicated in some of the arguments we have read, that this fails to engage with the fundamental change in the legal reality, since following the end of the transition period, the courts of the United Kingdom cannot re-refer questions to the Court of Justice if they disagree or require further clarification from that court. Well, we would refer you first of all to our supplementary observations, but perhaps a couple of additional points. The withdrawal agreement, by design, sets out transitional measures with the objective of allowing for an orderly withdrawal of the United Kingdom from the Union. It was negotiated to address precisely the change in relationship between the European Union's legal order on the one hand and domestic law as applicable in the United Kingdom on the other. When agreeing the terms of the withdrawal agreement, the parties to that agreement were therefore very much alive to the issue that there would, dare I say, inevitably be a point in time from which preliminary rulings could no longer be requested by the courts of the United Kingdom. Indeed, this change in legal reality may fairly be described as one of the objectives of the United Kingdom, who wish to alter the relationship between the Court of Justice on the one hand and the courts of the United Kingdom on the other. And this is relevant because a temporal limitation is explicitly built into Article 86.2 of the withdrawal agreement. Now, evidently, Article 267 of the treaty has no such temporal limitation. Courts of Union member states are not in a situation where there is a defined point of time at which the two legal orders will cease to interact. They are in a continuing relationship governed by the EU treaties. But this difference does not mean that the scope of the court's jurisdiction under Article 267 ceases to inform the scope of its jurisdiction under Article 86. The very purpose of Article 86 is to continue, albeit temporarily, the jurisdiction of the court in defined circumstances. And this temporal difference provides absolutely no basis for a construction of Article 89 of the withdrawal agreement that could go against the ordinary meaning of its terms. In short, the parties to the withdrawal agreement agree that judgments issued in application of Article 86 should be binding in their entirety on the courts of the United Kingdom, and they agreed this fully cognizant of the temporal limit of the continued jurisdiction that Article 86 conferred.
So in brief, what they agreed was you can't go back to the court to seek clarification. In the event that it's not very clear, you're going to have to do the best you can with it.
My lady, yes, they agreed that the binding effect would apply, even though there could be no such clarification or avenue for further clarification if that were considered necessary.
I mean, it's binding and it's binding, but of course, if it's difficult to understand, we have to decide, because we can't go back, what is binding, and having decided that, we're bound by that, to state the obvious.
But our primary observation is that it is binding as to the interpretation of European Union law.
Exactly. And
thereafter it is for this
if it
court.
were unclear as to what it was saying about European Union law, we'd have to do our best to interpret it accordingly, because we can't go back.
And thereby to also apply Union law as interpreted to the facts of the dispute
Of course.
before you, which remains fully within the scope of this court.
Exactly. I mean, I don't think it's all that difficult, in fact.
Well,
I mean, it's obvious. I mean, the words are pretty clear. I know you keep on repeating them, but binding in its entirety to me is about as clear as you can get.
Well, my lord, on that basis, perhaps I can move to the third issue.
Mm-hmm.
And this is the one that
I mean,
addresses...
you say the judge didn't get it, I mean, in a word. You say the judge was finding reasons why it wasn't binding in its entirety, which he wasn't permitted to do.
My lord, precisely, yes.
Yes. Although you don't want to get into all that, but that's why you're here.
That is why we're here.
Yeah. Exactly.
Then the third issue we address goes really to this question of whether the withdrawal agreement could be interpreted as conferring a right on the courts of the United Kingdom to rule on the scope and exercise of the Court of Justice under Article 86 of the withdrawal agreement. Now, this is a point on which you've already heard quite extensive submissions from Spain. It will perhaps come as no surprise in light of the observations I've already made that we say that the courts of the United Kingdom, like the courts of the member states under Article 267 TFEU, have no vires to either rule on whether the Court of Justice has acted in excess of its jurisdiction, and certainly not to disregard those interpretations of union law which it deems to have been ruled upon in excess of jurisdiction.
And you rely on all the cases that Mr. Young cited yesterday.
Those and perhaps others, but I will be very parsimonious in my references to authorities, given that you have already been taken to a large number of Court of Justice judgments.
Well, there seems to be a general consensus among the authorities that even if it were arguable that the court had answered a question which by a self-denying ordinance it had decided it wouldn't normally answer, or if it had gone beyond the scope of a reference, arguably, the only jurisdiction to rule on whether it had or not would be from the CJEU itself. And a national court has no business saying what the judge said, which is basically, you've gone outside of the reference. I deliberately didn't give you the power to decide this point, and therefore I can ignore what you said about it. That's really the thrust of the authorities we were shown yesterday.
My lady, yes, and that stems from the manner in which the European Union legal order has been constructed, yes, with the Court of Justice of the European Union, if, as you like, the apex court, with the authoritative interpretation and final say on European Union law.
And you say touring tours doesn't say anything different.
So then I will briefly address touring tours. This is a judgment, and this is the very narrow basis, in fact, on which we understand Mr. Justice Butcher to have suggested that he could reach an alternative conclusion. And that case is authority for the proposition that where there has been an explicit refusal in a reference, then in those circumstances the Court of Justice may rule of its own motion that it should not address that question. It says absolutely nothing, as my learned friend has already argued, about whether or not another court, certainly a national court, could then decide for itself whether there had been such an excess. But I will come to this shortly, but we also say that touring tours is not applicable in the circumstances of this particular reference. It's a point we've also addressed in our written observations. But if I may just say a little more about the reasoning of Mr. Justice Butcher, and in particular paragraph 209 of his judgment, which should be at page 267 behind tab 9. The logic of Mr. Justice Butcher in that sentence is that the judgment would not be binding because this is a corollary of the limited jurisdiction established by Article 267 of the treaties. And at paragraph 211, Mr. Justice Butcher finds in any event under the withdrawal agreement, the judgment could not bind the English courts if the interpretation of union law was not within the ambit of the preliminary ruling requested. Now, these findings seem to rely on a series of propositions concerning the attribution of jurisdiction under the EU treaties. And the first is that the European Court of Justice has a limited jurisdiction. And on this, we would submit that the framing of the nature of the court's jurisdiction is simply incorrect. Under Article 19 of the Treaty of the European Union, the Court of Justice has been conferred an extremely broad jurisdiction to rule on all matters of union law, save certain matters under the common foreign and security policy, as provided for.
Ms. Norris, do you actually need to go that far? I mean, you can more or less say CJEU is the exclusive arbiter, final arbiter of EU law. EU law extends actually to its own jurisdiction.
My lady, yes, that is indeed our proposition, but we noted that the judge considered, Mr. Justice Butcher appeared to consider that there was a very limited jurisdiction of the Court of Justice.
My point is simply that if that is right, you don't need to get into the substance
We would
of what
fully
Article 19
agree,
says.
but by way of completing the picture, we would argue that in any event, that portrayal of the Court of Justice's limited jurisdiction is itself doesn't reflect the way that the jurisdiction has been established under the treaties. And indeed, Article 267 is there to set up a dialogue between national courts because responsibility for the full application of union law is shared. And you've been taken through many of the authorities that support that proposition. Now, we say that the sharing of responsibility for the application of union law means that not all matters must be referred to the Court of Justice by national courts. There are certain circumstances in which references are mandatory, but I think we all agree they do not arise here. But what it does not mean is that the Court of Justice's role as the authoritative source of the interpretation of union law can be disregarded, and it certainly doesn't detract from the key principle that a national court cannot, even if it disagrees on substance, choose not to apply the judgment which is binding as to European Union law.
I think the distinction that the judge was trying to draw, perhaps not as clearly as he might have done, is the distinction between the role of the national court and the role of the Court of Justice. The role of the Court of Justice is to tell us what European Union law is, and the role of the national court is then to apply the law as stated by the CJEU to the facts of the case. And I think what he may have been trying to say there, rightly or wrongly, is that the Court of Justice has trespassed into the latter.
Well, my lady, that division of responsibilities is preserved by Article 86 of the withdrawal agreement. And whilst we say that it's certainly not for a national court to rule on whether the exercise of the jurisdiction was in fact appropriate, clearly this court needs to address certain arguments in which it's been said that the ruling shouldn't have been rendered.
Well, it might be worth asking you this in the light of the point my lady's raised. In English courts, we talk about decisions of fact, decisions of law, and decisions as to how the law is to be applied to the facts. And it may be that the judge, in accusing, I'm not meaning that word in a pejorative way, but in accusing the Court of Justice of having decided facts, was in fact saying, well, you were not entitled to say how the law, as you have determined it to be, should be applied to the facts of our case. And I imagine your submission is that the CJEU is in fact entitled to say, you have told me the facts of your case, they are not disputed, European law is this, and that means that the answer to the reference is Y, which may involve saying on the facts of your case, European law means answer Z.
Well, my lord, in a nutshell, yes, and we would go further than that and say that when exercising its jurisdiction, the Court of Justice is guided by the principle that its binding judgment should be of use to the national court to resolve the underlying dispute, and that this is precisely why it has a power to reformulate questions. Now, we don't understand there to be any suggestion that it cannot reformulate questions.
That would be a remarkable submission, since it does almost every time.
Indeed. So the question is really here one of degree as opposed to the power as such. Now here we would stress that what the Court of Justice did is absolutely not exceptional. Also in terms of degree, yesterday, my Lady Justice Andrew says, well, what happens if the court refers question A and gets an answer to question B? Well, we would say we're not there. But perhaps I may address that point also, is to say that judgments of the Court of Justice are binding on two different planes. They're binding erga omnes in the sense that they bind all courts of the European Union as to the correct interpretation of union law. That's what we could describe as a general interpretative function. And they're also binding on the referring court as to the dispute before it. Now, in that second sense, of course, the national court still remains the court with jurisdiction to determine whether union law is necessary to reach an answer on a particular point before it, and whether union law is dispositive at that point. But if it concludes it must apply union law, then it is the interpretation of union law as given by the Court of Justice that is binding.
Yeah.
So, my lord, if I may then turn to the final point that we propose to address in these initial observations, and that is, how is the term in its entirety in Article 89 of the Withdrawal Agreement to be interpreted? Well, we would suggest that, as has already been stated, this is somewhat unqualified as a term. Under union law, the entirety of a judgment refers both to the operative parts and to those grounds in respect of which that operative part is to be interpreted. And for that reason, we would also suggest that it's simply incorrect to consider the Court of Justice as the European Union as being in three parts, which we have seen that it's been reasoned that it's in three parts. The judgment of the Court of Justice gives an interpretation of Article 34.3, which must be interpreted in line with point 1 of the operative part. And perhaps we could just turn to that operative part of the judgment. And the judgment itself is behind tab 1 of your authorities bundle.
Quite interesting that Mr. Justice Butcher doesn't mention the requirement that the decision is binding in its entirety from Article 89 at all. Never mentions it.
Well, my lord, no, but that is the provision that we say is...
No,
It's just odd that he hasn't mentioned it.
odd that he doesn't mention it, since I assume somebody would have made that submission to him. Anyway. anyway,
Did you say?
we're looking at the Court of Justice decision.
Yes, it's 0038, page 0038, behind Authorities Bundle, tab 1.
Which paragraph? The dispositive
It's
paragraph?
the dispositive. And you see point 1.
Mm-hmm.
Now, that is the operative part of the judgment. That is the part of the judgment which is binding. And this means that a judgment entered in terms of an arbitral award is not always capable of constituting a judgment within the meaning of Article 34.3.
Mm-hmm.
With a view to assisting the court, if I may now address paragraph 71 of the judgment, as this was another point which elicited some questions yesterday. And that paragraph is at page 0036. Sorry, 36. We would suggest that the first part of that paragraph explains what a national court seized of a request that a judgment be entered in the terms of an arbitral award must do. It must determine whether the provisions and fundamental objectives of Brussels I regulation have been complied with, or if there would be a form of circumvention. And this exercise, or test, is one that all member states courts confronted with such a request must undertake. And that is the binding requirement we would suggest under union law. Now, the second part of paragraph 71, the court records that this was not done. We would suggest this might be understandable given that the interpretation is new. And the Court of Justice's judgment cannot be understood to undo the existence of the Hamblin judgment. What it does say is that the Section 66 judgment cannot be relied upon under Article 34.3 to preclude recognition of the Spanish judgment.
But are you saying that for the future, a court would be wrong to do what Mr Justice Hamblin did?
We say that as a matter of union law, a future member state court, when confronted with this situation, would need to apply the hypothetical test set down in the preceding paragraphs and ascertain whether or not a judgment in those terms could have been entered by the court.
And what is interesting is we're not a member state court anymore, but this decision is nonetheless of interest, but wouldn't bind, or could be decided not to bind, I think, to put more accurately, because it's English law for now, but there are provisions in the Withdrawal Act that allow the court to take a different view, but we're not there. That's not what we're doing here. We're dealing with a situation where we have a reference and a binding judgment. So we can leave all that to happy courts in the future. But as you rightly say, in another member state, this would be binding. This would be what Mr. Justice Hamblin in Italy would have to do in the future.
Indeed. And that is why we would say that paragraph 71 is of relevance in any event as a function of the court's general interpretative role in binding other member states as to union law.
But it doesn't take us, as it turns out, particularly far because of the submission you'd also made, which is it does not vitiate the actual registration of the judgment under Section 66.
Yes.
Yeah. I think it's pretty clear.
Well, my lord, indeed, I think that on that basis, and as you seem to have fully integrated the thrust of our submissions, which are in exactly as you have just summarised.
Well, save your time for coming back.
Indeed, we remain available to assist you with any further questions you may have, but for now I think we will conclude our observations.
It's extremely helpful, Miss Norris. Thank you very much. Mr. Hancock, at last you.
Waiting with bated breath, my lord. I'm going to start, if I may, my lord, my ladies, by taking you through a very short précis of how we've got here over many, many years. And I say that with feeling, having been involved with the case for all of those years.
So, I mean, we saw Mr Smuhar in your shoes. That was just when you were doing
No,
something.
I was on the other side.
Oh, sorry. Yeah.
Mr.
He
Young
was for
has,
Spain.
I'm Spain and France.
Mr. Young has taken over from Mr. Smuhar.
Right. Okay.
Mr. Smuhar appeared with Miss Dilnot for Spain and France, first time round.
Okay.
And
Sorry.
I appeared for the club way back when in 2013, and indeed in the arbitrations in front of Mr. Schaff, which I'll take your lordship and your ladyships to in a moment. But so, if one goes way back to where this all started, it all started in 2010, which was when the Spanish proceedings were commenced. And as the court knows, the Spanish proceedings involved criminal proceedings against the master. They involved civil proceedings against the master on the basis that if the master was criminally liable, he was also civilly liable for any loss occasioned by that criminal act.
Right from the start.
Right from the start.
Criminal and civil against them.
Criminal and civil against the master, civil against the owners on the basis that they were vicariously liable for the civil liability of the master, and a direct action claim and a CLC claim against the club on the basis that the owners were there assured, and on the basis that the club was under a liability under the Civil Liability Convention, statutorily, to pay compensation for pollution damage.
And who were the other parties to the claim, apart from Spain, the Kingdom of Spain?
The other parties were, there was a Spanish gentleman who was also a party to the claim, who was the gentleman who had sent the vessel out to sea again.
No, I'm not thinking of defendants, I'm thinking of claimants.
Spain and France. And
Yeah,
then
yeah.
there were a whole raft of other more minor defendants. So there were various municipalities of claimants, yes.
Yeah, that's what I meant. Local authorities,
Local authorities,
that kind of thing.
that's right.
I mean, lots of parties. I mean,
Lots of parties, hundreds of parties,
hundreds of parties.
hundreds of parties.
So when the claim began,
Yeah,
I mean, you know, we put a little heading on our claim that says between X and Y, and
Yeah.
sometimes X is a number of scheduled parties. I mean,
Yes.
This would be a claim brought by lots of people in Spain, Spanish people and French people.
but lots of people in Spain, then the French state and the Spanish state.
Right. Okay. What about the municipal authorities in France?
I'd have to check on that. I'm not sure that there were. I believe that there were some.
I mean, this is relevant in a way for us to understand because
Yes.
I think an argument is going to be made, or sort of was suggested by
Yes.
Mr. Young, that this was a proceeding for which Spain really can't be blamed.
And that's the point I'm going to.
Yes,
my lord.
yes, because there were so many people involved in it, and it was the natural place for Spain, the Kingdom of
Well,
Spain, to bring an action in
The-
respect of pollution
The moment
against
that the
Spain.
claim was brought, the civil claim was brought on the insurance, then that was an arbitrable claim.
No, I know all that, but what was that civil claim on the insurance brought in the 2010 Spanish proceedings
Yes.
by not only the Kingdom of Spain, but also victims
Yes.
of the pollution?
Yes,
It was,
yes.
yeah.
But obviously we are concerned here with Spain and France. My point is twofold. My point is that at the moment that those proceedings were brought, there would have been two answers to them, jurisdictionally. One is, and this goes to a point that my Lady Justice Andrews made, that under the terms of the regulation, then the proper place on the face of it for suing a defendant would be in the defendant's domicile. That is to say, in this case, London. That is subject to the specialist provisions of the regulation, which operate as exceptions to the general rule in the regulation, and the specialist exception that Mr Young has referred to is the insurance portion of the regulation. But it's not quite as simple as Mr Young has made out to your Lordship and your Ladyships, because there is, at the very least, room for doubt. We would suggest room for very great doubt as to whether, as a matter of Spanish law, it was open to Spain and France to bring their claims in Spain pursuant to the provisions of the regulation.
What about all the victims?
Well, the same would apply to them as well.
That seems strange to me at first sight. I mean, it seems to me obvious, I'm not for closing argument, but it seems obvious to me that a Spanish municipal authority injured by pollution would be full square within the specialist insurance provisions that say...
Well, let me explain to your Lordship why your Lordship is wrong.
Yes, good.
So,
Always
the
happy
answer
to be
to your
wrong.
Lordship's point, and exactly the same analysis applies to Spain and France and to all the municipal authorities, because they're all suing on the same provisions of the regulation on this hypothesis. The answer to your Lordship's point is that the relevant provisions of the regulation have to do with liability insurance. And as a matter of Spanish law, this is not liability insurance, because it is indemnity insurance, because of the existence of the pay-to-be-paid clause.
Yes,
And there are Spanish authorities, in particular a decision in a case called the C Bank, which was an authority which was discussed in front of the arbitrators.
But you lost this point in Spain eventually, or never argued?
No, it's never argued.
Never argued.
It was argued in front of the arbitrator. And I'll come back to the position in Spain, because, again, if one's looking at the regulation, the Spanish court should have examined its own jurisdiction of its own motion. That is what the regulation says, and it didn't. The court that should have done that was the Provincial Court of La Coruña. There was no consideration by the Provincial Court of its jurisdiction as a matter of regulation.
And you didn't go along and tell it to?
And we didn't go and tell it to. And in the context of a rather similar argument as to not going and seeking a stay on the basis of the arbitration agreement, that's something which, as I said to my lord and my ladies yesterday, was again raised in the arbitration as a ground for saying that the club had caused their own loss by failing to mitigate the position by taking an action in Spain designed to protect.
You weren't obliged to.
Sorry?
The answer is you weren't obliged to.
Well, the answer is, firstly, we weren't obliged to, and secondly, we certainly didn't act unreasonably in failing to do so, and that was what was found by both of the arbitral tribunals, because they found that by going to Spain in order to answer these things, we ran the risk of being found to have submitted to the jurisdiction in Spain. So, the starting
It's a small risk if you're going to contest the jurisdiction that you would be held to have submitted to it.
Well, that rather depends on the court that you're in, my lady.
But I mean, this is all back in 2010, right?
That's back in 2010.
And you took a conscious decision not to contest the jurisdiction in Spain. So I'm wrong. When you say I'm wrong,
Yes.
am I arguably wrong or definitely wrong?
Well, you're definitely wrong in my submission, my lord. Very
No, but I
respectfully.
know I'm definitely wrong in your submission. Am I arguably wrong because the point has not been decided authoritatively by a court with jurisdiction to decide it, or what?
Well, the answer, my lord, is that the Spanish court, as I've said, should have addressed this question
And
in
it
its own
didn't.
motion, and it didn't.
But I mean, there are arguments both ways. Would you
Yeah.
accept that?
I would accept that it's not an open and shut point,
Yeah.
if I can put it like that. I would submit that we have the better of the argument.
No, I understand the
But-
indemnity point.
But the reason that I raise the point is
Yeah.
because, in particular, the Assenshaven point
Yes.
all proceeds upon the basis that you were entitled as a party in the position of Spain to go to your home court. Now, just in parenthesis, this court and the Supreme Court, on an application for permission to appeal from this court, have held that Assenshaven does not apply to arbitration clauses. That was in the Prestige 3 and 4. That was before the CJEU judgment.
Can I just ask you this before we break?
Yes.
It troubles. I mean, this seems to me to be very far from black and white, because of the joined-up nature of Spanish proceedings. Let's start from this proposition: if you're going to bring criminal proceedings against a master in Spain, it's likely that you would bring them in the Spanish court.
Yes.
If criminal and civil proceedings are brought in the same proceedings against the master, it's likely that you'll bring them in the Spanish court.
Yes.
There must be, therefore, numerous claims, including against the party that you mentioned, namely the person who gave directions and told the master to turn left instead of right, or
Yes.
whatever happened, that could really only sensibly be brought in Spain.
Yes.
So, although your arguments may be entirely right as regards the claim by X against the club
Yes.
on this policy, or
Yes.
for money under this policy, it's a rather more nuanced question as to whether it was right or wrong, reasonable or unreasonable, or appropriate or inappropriate to bring an amalgam of proceedings like they have in Spain, which no doubt could occupy Spanish lawyers until the end of time. Indeed, it nearly has.
Well, my lord, I would say, with great respect, no. Because here we're dealing with arbitration proceedings. So you have to look at the parties to the arbitration.
Now, I'm not saying
itself.
I'm not saying that you're not absolutely right about the arbitration clause and all that. What I'm saying is that from Spain's point of view and from
Yes.
some of those parties' point of view, those proceedings, or a large part of them, may have been entirely justified.
And, my lord, that's why I say that I'm starting from the beginning because of the fact it's relevant to start from the beginning, so you can see that it's not actually a black and white position.
No, it seems to be a very
as far
grey
as Spain
situation.
is concerned.
No, as far as everybody's
But,
concerned.
Well,
That's probably
my
why
point
we're...
is going to be, and I will come back to this after at the lunchtime break, is that whilst it may have been unclear back in 2010, it became completely clear in 2012 when Mr Schaff gave his award, and in 2013 when Mr Justice Hamblin gave his judgment. Spain and France knew at that moment that they were obliged to arbitrate their claim.
Yeah, okay. Well, let's come back at 2 o'clock.
Absolutely.
Thank you.
All rise in favour.